Hi, everybody. Thanks for being here.
All right, folks. So it is at the hour, and we are going to go ahead and get started with our programming. And I just want to thank you all and welcome you to the Domestic Violence and Child Custody in Utah Courts. This is being presented by Ronni Bateman in collaboration with the Gender-Based Violence Consortium. So thank you all for joining today's event. We do want to let you know that this event is being recorded. And so for your optimal experience, please mute yourself and turn off your camera if you are not the speaker. This will help to ensure that no background sounds and all of that comes through. We also want to let you know that this event is being recorded by the Gender-Based Violence Consortium. The Gender-Based Violence Consortium's vision is to increase public recognition of and deepen public knowledge about gender-based violence through research, innovation, and collaboration. And so we do this in collaboration with research communities and enhanced educational efforts. You can learn more about us at gbvc.utah.edu. And if you have colleagues who for some reason have missed today's event, they can access the post recording that will be posted to our website as well as distributed with our listserv. So I'd like to now take a moment to introduce myself. My name is Dr. Annie Isabel Fukushima. I am the co-principal investigator and project lead for the Gender-Based Violence Consortium. And so I want to just welcome you all and thank you all for joining today's event. Please know there will be opportunities at the end of the presentation for questions. So please use the chat feature to go ahead and add any questions you might have. We'll go ahead and collect those and then can assist Ronni with answering those questions. And so that's when Q&A will happen, is after the presentation is done. And so just wanted to let folks know about the format. And so without further ado, we are all here to hear from Ronni Bateman. Ronni Bateman is an expert on domestic violence and child custody who is working with the Gender-Based Violence Consortium to deepen public knowledge on this pressing public health issue. Ronni has nearly 20 years experience working on gender-based violence issues and is a master's in public health student at Utah State University. So I'm now going to go ahead and hand it over to Ronni Bateman. Welcome, Ronni. And you are muted, so you can go ahead and unmute yourself.
Well, off to a good start. Can you hear me okay?
I can hear you excellent.
Perfect. Okay. Thank you, Dr. Fukushima. And thank you to everybody that joined us here today. I see a lot of familiar faces or familiar names anyway. So thank you all for taking the time to be here today. So today we're going to be talking about domestic violence and custody in Utah's court system. So Dr. Fukushima, would you please click on the first there? So nationwide and even in Utah, when domestic violence survivors escape from an abusive situation, they often have a difficult time protecting their children and themselves and keeping custody of their children. So that's what we're going to be talking about today, about this dynamic and about why it's happening and what we can do to change that. So first, we're going to discuss a couple of Utah cases that some of you may or may not be familiar with. The first one is Michelle Wolford's and her daughters. We've got a picture of them there on the right-hand side at the top. We've got a picture of Danny and Sydney and Brittany and their mom, Michelle. So this first case, Michelle and her husband, Brian, were married for 12 years. And over those 12 years, he was physically and emotionally abusive to them. And he He cheated many, many times on his wife, and in the process or over the course of their relationship, he saw 2 separate therapists and was told that he needed treatment for some kind of sexual deviance, that he needed extensive treatment. In 2004, Michelle took the children and fled to a domestic violence shelter, and Brian filed for divorce. All 4 of them, Michelle, Danny, Sydney, and Brittany, have spoken up about the abuse and asked multiple times for help. DCFS concluded that there was a reasonable basis to believe that Brian was responsible for abuse and neglect of Brittany. A social worker also confirmed that Michelle had been treated for PTSD related to domestic violence. In 2008, we see information coming forward from one of the therapists saying that Brian had never completed the sex therapy program that he was recommended to complete, and said, quote, any filial therapy program with Brian and the children could put the children at great risk. Brian engages Michelle in a custody battle for years, running up legal bills, dragging her back to court, refusing mediation, and keeps delaying a final ruling in the custody dispute. The guardian ad litem never even spoke to the girls. The judge never spoke to the girls, and he didn't allow them to testify. They were begging to testify. Neither therapist of Brian's was called to testify. The custody evaluator declared that the DCFS finding that Brian committed domestic abuse was irrelevant because it was not abuse against Brittany, one of the children, but only domestic abuse against Michelle in the presence of Brittany. Custody evaluator never even looked at the therapist's psychosexual evaluation of Brian and never talks to the therapist. Michelle's attorney fails to present evidence, preserve objections, properly cross-examine witnesses, call supporting witnesses, or raise arguments that can be used on appeal. The custody evaluator states in his February 2010 custody report that Brian admitted to, quote, a history of sexual contact with a child, and that the ethical standards of the Association for the Treatment of Sex Abusers clearly states anyone with such a history should have supervised visits with children, but he recommends custody be given to Brian anyway. Michelle was accused of brainwashing and alienation, and although she was only making $8 an hour at her job at the time, she was ordered to pay $500 a month to support Brian because he had no job. He was fired from his previous employment because of alleged sexual harassment. And because he had no job, he didn't have to pay alimony. So he was given primary custody of the girls, and he moved them to Kansas without notice from Utah. When the girls were here for the summer, one time with Michelle, they ran away. Several months later, Michelle found them and joined them. And when they were eventually caught, she was jailed on felony charges, and the girls were put in a detention facility for 3 months. And over the time period when they were missing after they had run away, they put out several videos on YouTube asking to be allowed to speak to the judge, that they were afraid of their father, that they didn't want to live with their father. And it's still, so after they got out of the detention facility that they were in for 3 months, they were sent back to Kansas and to a reunification program. I don't know how many of you know what these reunification programs are, but basically, when a child does not want contact with a parent, sometimes judges in Utah and all over the US will send children to these reunification programs where they are forced to bond with the abuser, essentially. These programs are unsuccessful. They're traumatic for children. The woman who ran this specific one only had a high school diploma. She's not a therapist. She had no other training that would qualify her to be doing this kind of thing with children. Court documents from other cases like this where children have been sent to this facility had them dry heaving in the corner and becoming suicidal because of what they were being exposed to. They're basically brainwashed and then forced to bond with the abuser. And during this time, they claim that part of the important part of the program is that they're not allowed to speak to or have contact with the preferred parent. So these girls were sent here and then back with their father. And that is the last concrete information we have about that. I do know that the oldest daughter, Brittany, left when she turned 18. And then as soon as the next oldest, I can't remember if it was Sydney or Danny, but as soon as she turned 18, she left as well. And the two older sisters then joined their mother in trying to get custody of the youngest one. So our next case here at the bottom, these pictures are of Jill Lloyd. I personally met the family here. It's just a heartbreaking story. So in 2017, Jill Lloyd was 36-year-old mother from Spanish Fork, engaged in a 10-year custody battle with her ex over their 11-year-old son. They had mutual restraining orders, and the police had been involved with them on multiple occasions for domestic violence and custody related issues before. Her ex-husband was not allowing her to see her son. And when she was stopped at a stoplight in West Jordan, he came up with a shotgun and shot her multiple times through the window of her car. And then he drove off and killed himself. To make it even more heartbreaking, she here on the right-hand side, you see she was engaged to Nick, who is a wonderful father, and they were going to be married. And so instead they had to have a funeral. So just very heartbreaking. So that was in 2017, Michelle, and that same month that Jill was murdered, there were, just to put it in context, there were 4 other domestic violence murders that month. Michelle Wolford's, her case that I know of lasted at least 14 years, which is just so stressful. So aside from these 2 mothers, there are so many others that are suffering. These are just 2 cases that where I personally knew either the mother or the family. All right, let's go to the next slide, please, Dr. Fukushima. We're going to talk about a couple definitions. For those of you here who are advocates, you'll probably already know these, but for those who aren't, we will have a quick review. So domestic violence, the definition can really be used 2 ways. Domestic violence, technically the definition is of abuse of people in a family, like it could be a cousin, a sister, a brother. But the way we're going to use it today, one of the more common uses is in talking about intimate partner violence. And I actually prefer the term domestic abuse because it incorporates more of the reality of domestic violence, which is all the stuff that's not physical. And an even better terminology, I think, is intimate terrorism, because that more accurately describes what being in one of these relationships feels like. So domestic violence can involve physical, emotional, psychological, sexual, spiritual, or financial abuse. It's caused by a belief system that embraces misogyny, entitlement, and power and control. Coercive control is another term that was coined by Dr. Evan Stark. And he came up with this to kind of describe the pattern of manipulation and humiliation, isolation, and gaslighting that abusers use to exert power and control over the other person. And gaslighting is a dynamic where the abuser makes the victim feel like they're crazy, denying things that actually happened, saying they didn't happen, things like that. So, and Dr. Stark, part of the definition that Dr. Stark came up with that I really like, that helps us to combat it, is that it's a pattern. It's not just something that happens occasionally. You can't say like, oh, this person gaslighted me one time, so that's coercive control. It's more of a pattern, an ongoing pattern of this behavior. And the purpose of it is to exert power over another person. It creates a loss of sense of self, and in that way, it's a liberty crime. Protective mother is a term used in this movement, which describes a mother who's fighting to protect her child in a custody dispute. Gender discrimination, when someone is treated unequally or disadvantageously based on their gender. Parental alienation syndrome. This one's a good time. So parental alienation syndrome was concocted by by Richard Gardner in 1985, I believe. And he wasn't a professor. He didn't have any science to back up this this thing that he came up with, but essentially he said that mothers in custody cases fabricate allegations of abuse and engage in a campaign to make the children despise the father. So it was a very, very sexist theory to begin with, but even though he had no scientific evidence to back it up, he published a whole bunch of literature and disseminated. He testified on behalf of alleged sex offenders in court, in custody disputes, and eventually he committed suicide. He said things like, the vast majority, probably over 95% of all sex abuse allegations are valid. There's a little bit of pedophilia in every one of us. Children want to have sex with adults and may seduce them. Keep the child connected to the abuser and tell the child that sexual abuse by a father is normal. So this guy was super twisted. He came up with this theory and abusers just latched right onto it. The problem with this is that it teaches practitioners and people to automatically approach allegations of abuse with a degree of skepticism, which makes it even more difficult for victims to get help. We all know that sometimes parents behaving badly, yeah, they might say something bad about the other parent or something like that, but fathers' rights groups keep trying to get this entered into the DSM, and it keeps getting rejected because most often when you have problems with a child and that child wants nothing to do with you, the more likely reasons for that are because of something you yourself did. whether there's been a time period of estrangement or if there's abuse, that is far more likely than a parent engaging in so much brainwashing to a child that the child does not want anything to do with that other parent. But strangely enough, when that dynamic does happen, it's abusers that are doing it. It's a common tactic that abusers use against victims. But when we use the alienation terminology, because of its sexist roots, because there's no scientific evidence behind it, because it is so useful to abusers, we are far better off to just call it what it is, which is domestic violence. It's domestic violence by proxy. They're using the child and the other parents, the victim's relationship with the child to hurt that other parent. So if we stick with calling it abuse instead of calling it alienation, all these other names, that since it has been so widely discredited, people will use many other names for it now. They just call it alienation, or they call it parental alienation. They leave out the syndrome part. And then it also kind of falls into the area of the friendly parent doctrine that's used in courts, where judges and commissioners, custody evaluators tend to want to give custody to the parent that seems friendly to the other one. Many times when you go to court, that abuser is going to be on it in the courtroom. He knows how to put on a good front. And so then you have the dynamic where maybe the victim is angry that all of this is happening, and then they look like the unfriendly parent. The abuser gets custody. So it's parental alienation syndrome, or PAS, is a very common tactic used by abusers. And you get a dynamic that where because the victim realizes that this abuse is going on, they start to try to hold back on letting the child go. They're afraid for the child's safety. And so then the abuser will say, oh, she's denying me access. She won't let me see my child. Yeah, sometimes it's for good reason. So, all right. Enough about that. Let's look at some statistics now. Thank you, Dr. Fukushima. Okay, so Utah, our statistics for domestic violence here are a little bit higher than the rest of the nation. 1 in 3 women over her lifetime will be a victim of domestic violence. That's a lot, you guys. It's like if you're hanging out with your woman, you're hanging out with 2 of your friends, then odds are one of you is going to be stuck in this kind of situation at some point in your life. 40% of adult homicides in Utah are domestic violence related. That is really high. Women are 10 times more likely to die from domestic violence related homicide than men. And every year, 80 children in Utah are present at the homicide or the attempted homicide of their mother. I can't even imagine how traumatic that would be. Since 2008, nationwide, 859 children have been murdered by separating or divorcing parents. That's a lot of opportunities where you had abusers and victims in a courtroom, where a judge or a commissioner or a custody evaluator, for that matter, could have made a decision that would protect children. When you have domestic violence dynamics, it's also very likely that there will be child abuse of some sort. 30 to 60% of abusers also abuse their children. And strangely enough, I have noticed this correlation that so many abusers also sexually abuse their children. So when you see a lot of these custody cases, a lot of times there will be domestic violence and there will be child sexual abuse alleged as well. They're 6 times more likely to sexually abuse their children. And these children, this is the relationship dynamic they learn when they're growing up. So they're much more likely to become abusers or victims themselves. And leaving is dangerous for victims. 35% of domestic violence survivors say that when they leave the relationship, the abuse gets more severe. And they have a 6-fold risk of being murdered during that time. It's a very dangerous time for them. All right, let's talk about the effect of all of this on survivors now. So domestic violence for adult survivors oftentimes results in complex post-traumatic stress disorder, anxiety disorders, depression, and we're learning more and more now how often trauma in our lives and things that happen in our environment affect our body and are reflected in us physically. So they have a much higher incidence of autoimmune diseases. And because of everything they're going through, they will tend to miss more work. It makes them not able to be the best parents they can be. You know, when you're under so much stress, it's difficult to have to be at your best in many different ways. Their productivity is impaired, and really it does a lot of damage to survivors. And for children that are exposed to domestic violence, we know now from the adverse childhood experiences, talking about those traumas that happen in childhood, that when children are exposed to those, especially over long periods of time, that comes out in their body, in their behaviors. Children that are subjected to ACEs, adverse childhood experiences, are more likely to develop mental health problems, to develop illness. We see the effects of ACEs reflected in 7 of the top 10 leading causes of death. A huge percentage of our homeless population, our prison population, all can trace a lot of that back to these adverse childhood experiences. Also, we see intravenous drug use go up in these children. We see teenage pregnancy, not graduating from high school. So many issues in our society can be traced back to adverse childhood experiences. And of course, these children also, again, may have difficulty in their adult lives developing healthy relationships and become the abusers or victims. And communities, all of us are affected by this dynamic. When our homeless population goes up, when our percentage of incarcerated people goes up, it's just the consequences of these ACEs are reflected everywhere. It affects our families, it affects our friends, our teachers, our neighbors. The cost of our healthcare, crime goes up, and it costs the United States as a whole billions of dollars every year related to domestic violence and child abuse. In terms of law enforcement, court costs, shelters and services, child protective services. Then you have on top of that lost potential of all these victims, sick days, missed work. It just goes on and on. We could save a lot of money, and I believe we've changed the world if we did a better job of protecting victims. Let's see. Okay, next one, please. Okay, so challenges that survivors face when they're trying to protect their children. Let's look at the court system first. So there's several different ways that the court system is involved in this. In terms of legal standards, very often judges, custody evaluators, when we're talking about the court system, we're talking about a lot of people. There's a lot of people involved in these cases. You have custody evaluators, you've got guardians ad litem who are appointed attorneys for the child. You have commissioners, you have judges, you have other people that are, let's see, what are they called now? Like parenting coordinators, or people that are special masters, people that are supposed to help the parents work everything out. You have attorneys, there's just a lot of different people that get involved. If DCFS, Department of Child and Family Services, is involved, then you've got them too. You have police officers. So court system, I'm kind of using a broad brush for that. But ignoring or minimizing evidence of abuse in custody determinations. Judges, custody evaluators, and commissioners have been known to do this fairly often, too often. Judges, commissioners, and custody evaluators will ignore the law. They will not use the correct standards of evidence, and they ignore recommendations from the National Council of Juvenile and Family Court Judges, the American Professional Society on the Abuse of Children, and the American Bar Association. So all of these are good organizations that have recommended positive standards for protecting children. And but they're ignored by the courts. Unfortunately, I've heard way too many times the courts in Utah, the district courts specifically, that it's the wild, wild west, because you never know what's going to happen. There's just way too much discretion. I mean, you know, we live in a state that likes to not have too much oversight, but there's a little too much there, because under the best interests of the child standard, which is what we use in Utah, there's a whole slew of stuff that a judge can consider, cannot consider, how they're going to weigh it. It's just, it leaves far too much open to the preconceived beliefs and biases of our judges, which is a huge part of why this is happening. Gender discrimination against women in Utah courts. First of all, gender discrimination is illegal in courts in Utah and nationwide. Women are held to higher parenting standards and a higher burden of proof. They're judged for working if they need to after the divorce. They're judged if they don't have a job. They're judged if they're single, a single parent, and they're judged if they get into a new relationship. And because of economic inequity that women face after divorce, generally after a few years, men's income goes way up and women's income goes way down. And so because of that, they have unequal access to the justice system. Attorneys are very, very expensive. It requires a lot of time off work, things like that. And when, especially if a mother has custody and primary physical custody and is, you know, that generally means that she's bearing the majority of the cost of raising the children. And so they have unequal access, and you get a situation where the children end up going to whoever can afford the best attorney and pay the most attorney's hours. And so you have situations where abusers just keep bringing them back to court to run up run up attorney's fees. So one of the most disturbing things I found in all of this was so around the 1980s, 1985-ish, the women judges started speaking up about the gender discrimination that they were seeing in the court system, and nobody believed them. So it was recommended that the states convene task forces to look at this issue. So Utah, to our credit, was one of the first states to complete one of these evaluations. And so in 1990, actually, it started in 1986. In 1990, the courts in Utah, the Judicial Council was given a report by this task force that showed that all of these problems of gender discrimination that we're seeing right now, that most of these problems were rampant in Utah's court system. This is in 1990. We've known about this for 30 years, and we're still seeing the same problems today. So that's a little depressing. Not gonna lie. So we have task force reports from more than 40 different states, 30 different jurisdictions, and Utah. And batterers are not held accountable for violating court orders. And in situations where there are allegations of abuse and they have been found by a preponderance of the evidence to be abusing people in their family, they should bear the burden of proof for resuming contact. Okay, now we can go to the next one. Sorry, thanks. I got wound up on that. Okay, so now we're going to talk about culture in the legal system. As we were talking about earlier, there's an ongoing disbelief when survivors come forward about experiences with abuse. And the literature shows that when domestic violence survivors come forward about abuse, they're believed less than half the time, only 41% of the time. There's victim blaming going on. Courts will establish mutual restraining orders, which basically says, okay, you both got problems, like we're just going to keep you from each other, which in effect puts blame on victims instead of putting it where it needs to go, on the abuser. And victims get stuck in a catch-22 where if they stay, they're blamed for the abuse. They're blamed for not leaving. They're blamed for not protecting the children or for not speaking up. And if they leave, if they're in this very situation in the courts, they're blamed for leaving. They're blamed for speaking up. They're accused of false allegations and alienation. So they're just kind of damned if they do, damned if they don't. Next one, please. So the court system's response is that abusers are given unsupervised visitation. A very, very low, rough estimate is that 58,000 children every year are sent into custody with domestic violence abusers. And because these children are stuck in that situation until they are 18, there are millions of children living with abuse when it's entirely preventable. So when abuse is credited, when the courts admit that there is abuse, 13% of the time, the abuser still gets unsupervised visitation. When it's just child abuse and not domestic violence, that number goes up to 20%. So 20% of the time, when victims come forward, the abuser gets custody anyway. When they've done studies that look at the experiences of survivors in the court system, we see that these custody decisions are keeping survivors in danger. They, part of the whole reason they're leaving this relationship is to escape from the abuse and to protect their children. But when they're forced to share custody with an abuser, they're being tied to that relationship and enabling the abuser to continue harming them. And then when they go to court, they're being subjected to institutional abuse and re-traumatized. Survivors say that when they went to court, 60% of them were again traumatized by the abuser, and 83%, even higher than that number, were traumatized by the court system and the court process. 52 out of 53 of them regretted even going to court. The effect this has is one of silencing victims. It has a chilling effect that they don't want to come forward, and they stay with their abusers because the court system ends up being sometimes even worse than the abuse that they dealt with in the relationship. Survivors are held responsible, in effect, for improving and even facilitating the child's relationship with the batterer. Can you imagine escaping from a relationship like that, where you're terrorized and then having to tell this little innocent child that they have to get along with that parent? It's excruciating for a mother to have to do. And when mothers and survivors lose custody and they're unable to protect their children, it's highly traumatic. And it leaves mothers with deep feelings of betrayal by the system and society. Children it's very harmful to take children from their primary attachment figure. That should be one of our primary goals, is to keep those children with the parent they are bonded to. I jumped around here on my notes. So in the end, the courts have tried lots of different things. They're sending them to these reunification programs. They're ignoring the abuse. They're doing all these kinds of things. They've tried everything except for holding the batterers responsible for changing their own behavior. Something that really, really struck me, one of the foremost researchers and an attorney that deals with these cases said that out of hundreds of cases that she has either litigated or researched, not one of them, not one case, did the courts say to the abuser, hey, it's your job to fix your behavior and then you can interact with these people again. Never once. Like, yeah, it's a little maddening. Let's hold them responsible. All right, let's see. So the next one we're going to look at is batterer tactics. Batterers tend to present as victims. They use parental alienation syndrome. And when parental alienation syndrome is used, mothers, the rate of mothers losing custody goes up doubly when parental alienation syndrome is used. And there's a drop in the crediting of abuse to 18% for child physical abuse. And the scariest part of that is that 2% only of child sexual abuse allegations are credited, which they're basically impossible to prove. Only one case out of 51 was believed. Litigation abuse, abusers will drag them back to court over and over, cause them to miss work, lose their job. It's another power and control move, and they threaten to take custody. They'll withhold daycare and medical payments, and 70% of abusers use this access to continue abuse. They use the children as a weapon, as informants. tracking and monitoring the phones, passing threatening messages through them, withholding medical consent, and they do things to disrupt routines like not letting the children get enough sleep, not giving them their medications or following diets, not helping them with their homework or being late for exchanges. And they either, if survivors come in and they're traumatized, they will portray the survivors unstable and not capable of parenting. If the survivor is angry, then they will say that she is uncooperative or that she's lying about the abuse. How could she be a victim if she appears to be angry and strong? Next one, please. Okay, so one of the other reasons that it's difficult for survivors to protect their children is because of fathers' rights groups. And make no mistake, women are involved in these groups too. They emerged in the 1980s in response to feminism and child support enforcement orders. These are different from other fathers groups that are created to promote fatherhood and male responsibility. These groups are all about reinforcing patriarchy. They use equal rights language. A lot of times their very names will have parents' rights or children's rights. They're very intelligent in how they go about things. They use custody to reduce child support. If you have joint custody, the child support amount goes down. They believe that child abuse should not be a factor in custody determinations. They push the false narrative that false allegations of abuse are very common, which they are not. And they distort abuse as mutual combat, which it also is not. They push the myth that victims are abusive. They are very organized and they lobby to change laws, impact legislation, create misleading research. They attack IPV funding and they spread misinformation. One of the sad parts of this is that you also get good fathers who are trying to have a relationship with their children where maybe the mother is not allowing them to see the children. You get them caught up in these groups, unfortunately, because they're looking for support. If you click on the right on the next one, Dr. Fukushima, please. So the Southern Poverty Law Center lists fathers' rights groups as misogynistic hate groups. Similar, and the way they operate is very similar actually to white supremacist groups that we're seeing a rise of. They use hate and they claim reverse prejudice. Next one, please. So the reality of this is that we have a situation where abusers' rights are being are given higher priority than victims' rights. And essentially, in an abusive dynamic, the victim's silence is the abuser's greatest weapon. The reality of this is that fathers' rights groups are abusers' rights groups. There's a connection here. All the dynamics you see with abusers, how they try to control the narrative with Darvo. They use misinformation, hate, misogyny, acceptance of abuse. They use joint custody to reduce child support. They use power and control and financial abuse. All of those dynamics you see with abusers, you see with fathers' rights groups. Next one, please. Okay, so let's talk about some solutions here. So the first one that I'd like to talk about is education. So the courts, we need to teach the courts how to be aware of and avoid and compensate for gender discrimination. We all have these kind of social cognitive processes that we use in life, and where we use a set of biases and belief systems and heuristics to figure out what we believe about things. And then we use shortcuts to kind of simplify our life, brain shortcuts, essentially. So a lot of it is unconscious or unintentional. So we need to teach people in our court system how to be aware of and avoid this kind of discrimination. They need education in accurate, trauma-informed domestic violence training. All of them, anybody that comes in contact with victims in this system. Many have some domestic violence education, but it's either outdated or it's just not enough. It's misleading or patently false information. Fathers' rights groups and those who support their ideas have been very effective at getting into education. And so we have an ongoing problem where people are getting poor information. It should be provided by domestic violence experts and advocates. They need to learn how to do risk assessments, learn about the effects on families, batters tactics, post-separation violence. Many of them believe that when the survivor divorces them, that the abuse ends, but that is not the case. The most recent passage of VAWA incorporates Caden's Law, which gives, I think, several $1 million to the state for incorporating more domestic violence education for court professionals. Next one, please. So in terms of policy, we need to, courts need to engage in careful fact-finding first. There should be a presumption against custody for abusers. Evaluators should be held to established standards, greater accountability for state actors, and the friendly parent statute should not apply in abuse cases. We need to prevent litigation abuse by ordering abusers to pay fees, hold them in contempt, ban them from filing, and refer attorneys for disciplinary action. We need to strengthen protections against coercive control and psychological abuse. And many of these things, if you did them to a stranger, they'd be very illegal. But for some reason, it's not when it's an intimate partner. We need child-centered, trauma-informed therapy. This is a long one. Child-centered, trauma-informed, therapeutic jurisprudence specialty domestic violence courts that would put victims first. And we need to hold bettors accountable. Next one, please. Monitoring and evaluation. We should have someone designated in each judicial district to resolve complaints of gender discrimination and oversee ongoing efforts for equality. Special attention for remedies that protect victims and the rights of the accused. We can do both at the same time. Improve documentation and record keeping, surveys, and periodic examination of the data. Next one. So this, because so many different organizations are involved, this provides us, actually, let me give a little plug for our study here. So Dr. Fukushima and I are conducting a study of domestic violence survivors involved in these custody disputes in Utah. So please feel free to contact me or to refer someone that you might know. So, as I was saying before, because this is such a widespread issue, this really presents a great opportunity for intersectional collaboration of so many different organizations in Utah. The Administrative Office of the Courts, the Legislature, the Judiciary Committees in each House, and the Child Welfare Legislative Oversight Panel, DCFS and the Department of Health and Human Services, Judicial Conduct Commission, Utah State Bar, and the Attorney General Reyes and Governor Cox. This is a great opportunity for us all to come together and to work on this. So, to be clear, this is not an issue of men versus women. This is an issue of good parents versus those who terrorize, beat, and infringe upon the liberties of their spouse and children. We need to invest in prevention using public health and a human rights approach. And the benefits to people in our state individually and to our state as a whole are massive and could save us a lot of money. We're Utah. We believe in families. We believe in supporting families and protecting the innocence of children. So I think 30 years is long enough. Hopefully you all agree. So let's work together and get this fixed. Thank you everyone for being here. We are going to discuss the results of our study in October. So please feel free to get registered for that one too. There's a link there. And we'll have it posted in other places as well. You can check the Gender-Based Violence Coalition's website afterwards. Sorry, consortium. Thank you all so much for being here. And now we'll take some questions.